3 days. I had been in my new home for exactly 3 days when a black SUV pulled up to my curb and a woman in a polo shirt with a laminated badge stepped onto my driveway like she owned it. She didn't knock, she didn't wave. She walked straight to the side of my property, looked at the land I had legally purchased, and wrote something on a clipboard. Then she handed me a notice, a fine $50,000, before I had even unpacked my kitchen. She looked me dead in the eyes and said, "That strip of land was always ours. You just bought it before we could file. That's going to cost you." I looked at the paper. I looked at her. And I thought, "Lady, you have no idea what I do for a living." But before I walk you through exactly how I dismantled every single thing this HOA thought they had on me, hit that subscribe button right now. This channel is called HO Drama Neighbor, and if you're a homeowner, a future homeowner, or you've ever been pushed around by an HOA, this is the channel that fights back with facts, law, and receipts. Subscribe. You're going to want to be here for this one. Let me take you back to the beginning. My name isn't important. What's important is that I spent 11 months searching for the right property. I'm not a first-time buyer. I've purchased and sold real estate before. I understand title searches, deed records, easements, and property surveys. The property I bought was a 3-bedroom colonial in a mid-sized suburb in the southeast. Nice neighborhood, mature trees, well-maintained streets. The kind of place where you assume your biggest problem will be a neighbor's dog or a fence dispute, not a full-scale legal war. There was a narrow strip of land, roughly 18 feet wide, running along the entire left side of the property that was listed separately in the county records. It had its own parcel number, and according to the title search, it had been sitting in legal limbo for just over 4 years. My agent advised me to purchase both parcels separately, merge them, and record the merge deed before closing. Both purchases were clean. Both went through. Title: I had a survey done, had everything recorded at the county courthouse before I received my keys. I moved in on a Saturday. By Tuesday morning, the black SUV was in my driveway. Her name was Valerie Higgins, and she was the HOA's designated Community Standards Director, a title she clearly took as a mandate from a higher power. She had the energy of someone who had never been told no in a professional setting. She didn't introduce herself. She handed me the notice first. "Violation notice and fine assessment," she said. $50,000, due within 30 days. I said, "May I see the CC and Rs?" She said, "You'll receive a copy when you formally respond to the notice." I said, "I'm going to need you to leave my property now." She smiled, the kind of smile that is not actually a smile. I went inside. I sat down at my kitchen table, which was the only piece of furniture fully assembled at that point, and I opened my laptop. I pulled up the county recorder's website. I pulled up the HOA's recorded governing documents, and I started reading. The HOA SCC and Rs, recorded in 2009, contained a provision buried in Section 14, subsection C, Paragraph 7, that stated any undeveloped or surplus land parcel adjacent to common area could be subject to a community right of first refusal if the HOA formally recorded a notice of interest with the county within a qualifying period. I searched the county recorder database for any notice of interest filed by this HOA against that parcel number. There wasn't one. Not in 2009, not in 2015, not ever. The HOA had never filed the required notice. I attended the next HOA monthly meeting, which was 11 days after receiving the fine notice. I sat in the back row. I did not speak. I watched. Valerie presented the situation to the board like a prosecutor giving an opening statement. She described my purchase as predatory. She said I had circumvented the community's long-standing intentions. She said the fine was a deterrent and that the board had the authority to escalate it to $2,500 per day. One board member, an older gentleman in the second seat, asked quietly whether the HOA had filed the required right of first refusal notice. Valerie said, "That's a procedural detail. The intent has always been clear." The older gentleman said, "Intent isn't a recorded document, Valerie." She moved on. On day 20 of my 30-day window, I sent my formal response, not by email, by certified mail. Return receipt requested. The response was 14 pages. Pages 9 and 10 were a legal summary concluding unambiguously that the right of first refusal provision was void as applied because the prerequisite filing had never been made. Page 12 was a notice that if the fine was not rescinded, I would be filing a complaint with the state's HOA regulatory office and initiating a civil action for harassment and abuse of process. The following Monday, I got a phone call. Her voice was different. The clipboard confidence was gone. "We'd like to schedule a meeting," she said. I said, "Everything goes through my attorney now." She paused. "We think there may have been a misunderstanding." I said, "You handed me a $50,000 fine 3 days after I moved into my home." "That wasn't a misunderstanding. That was a decision." I hung up. 2 weeks later, my attorney forwarded me a letter from the HOA's legal counsel. The fine was being rescinded. The board had reviewed the documentation and determined that the notice had been issued in error. The regulatory inquiry discovered that over the preceding 6 years, Liss HOA had issued 41 fines to homeowners, 18 of which had no documented basis in the CC&Rs. The total amount collected on baseless fines was over $94,000. The HOA was ordered to repay every dollar with interest. Valerie Higgins resigned within 48 hours. And that strip of land along my property line, I had it landscaped, put in a stone pathway, some ornamental grasses, and a small iron bench by the retention pond. Every time I sit out there in the morning with my coffee, I think about that Tuesday, 3 days after I moved in, when a woman with a laminated badge handed me a $50,000 fine. And I think about 14 pages of documentation. And I think about how arrogance, when it meets preparation, doesn't stand a chance. So I want to ask you, if you had been in my position, what would you have done? Drop your answer in the comments. Like this video, share it, and subscribe to HOA Drama Neighbor, because the next story is already coming and you do not want to miss it. Stand your ground, know your documents, and never, ever pay a fine you didn't earn.